The Leader of the Opposition.
Thank you, Mr Deputy President. I lead for the opposition on this package of cognate bills, the Mining and Petroleum Legislation Amendment Grant of Coal and Petroleum Prospecting Titles Bill, the Harmonisation Bill, the Land Access Arbitration Bill, the Work, Health and Safety, Mines and Petroleum Harmonisation Bill, and the Enforcement of Gas and Other Petroleum Legislation Bill 2015. The opposition will not be opposing the bills. We will, however, be proposing constructive improvements. The package of bills contains what I think can fairly be described as significant changes to the law and administration in the mining and petroleum industries of the state. The package of 5 bills will significantly overhaul the laws that regulate mining and petroleum exploration licences, assessment and mining leases, workplace health and safety regulation, the enforcement of land and access arbitration in the mining and petroleum industries, and to legislate to make the Environmental Protection Authority responsible for investigating and instituting proceedings for petroleum offences and other offences under other environmental legislation as a step towards making the EPA the single regulator for all environmental offences in this space. The government no doubt will claim that the bills together implement recommendations made by the Chief Scientist and Engineer in her September 2014 report on coal seam gas and of course the government's own gas plan. However, while no doubt what the legislation does in relation to the grant of coal and prospecting titles and the harmonisation provisions is it modernises and updates a lot of the provisions that deal with the allocation and the administration of various titles and ensures a consistent approach across all of the resources sector, ensuring that petroleum is brought into essentially the same regulatory regime, and of course it implements a range of other new measures and of course brings the petroleum sector under the same occupational health and safety regime as currently applies in the minerals and other resources sector. And the final bill, the enforcement bill, provides for the EPA to take on more directly regulatory functions it now performs under delegations. In relation to the government's claim that these bills take a step closer towards implementing the recommendations made by the Chief Scientist and Engineer in her September 2014 report on coal seam gas, it's worth members reflecting on the fact that the Chief Scientist made some 16 recommendations, of which 12 or 13 are of the nature that would make them appropriate to be implemented through legislation. And of course what is notable about this legislative package now before the Chamber is not only its content but more notably what it lacks. Of the 13 recommendations made by the Chief Scientist and Engineer, which on our view are amenable to legislative implementation or which we think for more abundant caution and safety needs legislative underpinning to make effective any administrative action taken, there is no action taken on 10 of those 13. And I will briefly enumerate those where, as we said, there is no action. There's no action on recommendation 4, which was that the full cost to government of the regulation and support of the industry, CSG industry, be covered by the fees, levies, royalties and taxes paid by the industry, and an annual statement made by government on the matter as part of the budget process. Now, no doubt the government will say, well, a lot of this can be done administratively, but this is quite complex and we think would need some legislative underpinning. Recommendation number 5, which is the government use its planning powers and capability to designate where CSG activity is permitted to occur. Turning it on its head, Mr Deputy President, it also calls on government to work out where there should never be CSG activity. We think this is sufficiently important that it goes beyond whether or not the government should simply rely upon its planning powers. We think even with the use of planning powers there needs to be legislative underpinning and there is no action taken in this package. Recommendation 8 was that the government have a target and outcome-focused regulatory system with a number of features, 2 of which I will mention. Regularly reviewed environmental impact and safety targets optimised to encourage the uptake of new technologies and innovation, and automatic monitoring processes that can provide data sent to and held in the openly accessible whole of environmental data repository, which will help detect cumulative impacts at project, regional and sedimentary basin scales and used to inform targets and the planning process. Recommendation 9, a robust and comprehensive policy of appropriate insurance and environmental risk coverage of the CSG industry to ensure financial protection, short and long term. Not present. I'd be interested to know if the government's taking any administrative action to implement this. Recommendation 10, of course, was that the government commission and design the whole of environment data repository for all state environment data, including data collected according to the legislative and regulatory requirements associated with water management, gas extraction, mining, manufacturing and chemical processing activities. Not present. Recommendation 11, that the government develop a centralised risk management and predictive tool for extractive industries in New South Wales. There's a lot more detail, Mr Deputy President, which I won't enumerate. Again, not touched on in the legislation. Recommendation 12, that the government establish a standing expert advisory body on CSG and possibly extend it to all of the extractive industries comprising experts from relevant disciplines, particularly ICT and the earth and environmental sciences and engineering, drawing on other expertises as necessary. Not provided for. Now, no doubt the government could establish this by administrative action, but considering what the Chief Scientist said should be the function of this body, we think it needs legislative underpinning. Recommendation 13 was for 5 parallel and intersecting supplementary actions to support those others that I've mentioned, not dealt with in the legislation. Recommendation 14 was that the government ensure all CSG industry personnel, including subcontractors working in operational roles, be subject to ongoing mandatory training and certification requirements, and that this should extend to audits, training and accreditation functions undertaken by government for the industry. Not touched on. And of course, very importantly, recommendation 15, that the government develop a plan to manage legacy matters associated with CSG, covering abandoned wells, incomplete compliance checking and the collection of data not yet supplied under licences and regulations. And the Chief Scientist made it very clear there needed to be a formal mechanism to undertake this. Again, not touched on in the legislation. So 10 of the 13 matters that could reasonably be expected to be made, have provision made for under law, not addressed, not touched on, not even mentioned in passing in this package. This package, we think, is a significantly missed opportunity in this regard. We will be moving some amendments to address these shortcomings in the legislation, and our amendments will cover at least 8 of those that I have mentioned. There are some where we simply haven't had the time to prepare those amendments, but the amendments that we propose will comprehensively provide a framework for and provide for the addressing of those matters where the government has found itself asleep at the wheel in preparing this package for Parliament. I'll turn now to a little bit of detail about each of the bills. The Mining and Petroleum Legislation Amendment Grant of Coal and Petroleum Prospecting Titles Bill 2015 establishes and mandates, with some exceptions, a new competitive selection system for the granting of an exploration licence or an assessment licence in relation to controlled release areas under the Mining Act, or an exploration licence, assessment lease, production lease or special prospecting authority under the Petroleum Onshore Act. The bill provides that applications will only be able to be made by a competitive selection process provided for in Schedule 1, capital A, which is to be inserted in each of the Mining Act and the Petroleum Onshore Act, or by the existing holder of an exploration licence or mining licence over land in the same area and in relation to the same mineral, or the existing holder of an exploration licence over the land concerned in relation to petroleum matters. As the Minister noted in his second reading speech, and I'm sure it was also in the Honourable Parliamentary Secretary's speech, the Independent Commission Against Corruption has recognised that there are limited circumstances where it makes sense for an existing coal operation to be able to acquire an exploration licence for adjacent land, for example, to support existing operations, to add to an existing mine, or to extend the life of a mine. I think the Minister gave some other examples as well. However, the legislation is not limited to these matters. No matter. The legislation will permit the Minister to constitute a controlled release area for specified minerals under the Mining Act. It constitutes the entire state as a controlled release area for coal, I think under Section 368 capital A, or proposed Section 368 capital A. Now, interestingly, in his second reading speech, the Minister, I think, in one of those fits of enthusiasm that sometimes besets persons in public life, said, and I quote, "The bill makes the entire state a controlled release area for coal and petroleum." Coal and petroleum. If we look at the bill, and we look at page 4, I think it is, no, page 6, proposed Section 368 capital A, controlled release area, it does in fact make the whole state a controlled release area for coal, but Schedule 2, which provides for amendments to the Petroleum Onshore Act, doesn't do any such thing for petroleum. Now, as has been explained to me, and I just pause to say I thank Minister Roberts and his staff for briefings sought and extended to the opposition, and I thank also the staff of Minister Speakman, who also provided briefings for the opposition as requested. And as I understand it, the view taken is that there is no need by this legislative package to make the whole state a controlled release area for petroleum, because that is already achieved by other means. And the importance of this mechanism is as follows, and I quote the Minister, and he says, by using the device of controlled release areas, and I quote, "This means that coal and petroleum companies will not be able to apply for a title without the government having first decided where and when it wishes to release areas for exploration," unquote. Now, I can see how that is achieved for coal, but this legislation doesn't do that for petroleum. As I said, those matters may be attended to by other legislative instruments, but that has not been spelt out by the Minister or the Honourable Parliamentary Secretary in any contribution on this package, and I call upon the Parliamentary Secretary in his reply speech to enumerate with great clarity how the controlled release area function for petroleum is already in place. If it's not, there is an omission in this package. In any case, amendments that will be moved by the opposition will deal with, in other ways, the issue of coal seam and other unconventional gas licences and operations. We'll be moving a suite of amendments that address not only the shortcomings of this package in implementing the recommendations of the Chief Scientist, but in addressing what the opposition has been campaigning around on the issue of coal seam gas on a fairly comprehensive basis. The legislation also removes the existing prohibition on the granting of an assessment lease over land the subject of a prior application for an exploration licence or assessment lease. And in the context of a competitive selection application for the grant of an assessment lease, it removes the requirement for the Minister to notify affected government agencies of a proposal to grant an assessment lease and to resolve any objections to such an application. I pause there. The policy rationale for removing from the Minister this obligation also has not been addressed in the second reading speech, and I look forward to the Honourable Parliamentary Secretary's comprehensive address on that subject. But just so the members of the government are not unduly alarmed, the opposition will have an amendment that will address this shortcoming in the bill, so you need not worry. You'll just follow our lead and all will be well.
Always happy to help.
Always happy to help. I acknowledge that
We're
objection.
alert but not alarmed.
We are certainly engaging with the subject matter of this package in a constructive way, accepting what the government has proposed and trying to improve on those areas. Now, as I indicated, because the whole state will be a controlled release area for coal, the government says we'll have to determine and decide what areas should and should not be the subject of exploration before coal companies are able to apply for a title through the controlled release area mechanism. The government says this will also be the case for petroleum and gas, and no doubt the government will say that this does in fact implement recommendation 5 of the Chief Scientist recommendation, but as we say, we don't think there's anything in this package that prevents government, small g, from repeating the mistakes of the past regarding the issuing of exploration licences from coal seam gas from reoccurring. I know the government says it's going to have a strategic land use framework, but that doesn't guarantee errors being made, so we will propose as amendments to this legislation essentially what is now included in the coal seam gas moratorium private members bill. Mr Deputy President, that has already been second read in this place. The bill allows for government to undertake limited exploration activities, that is in proposed section 13 capital D. This is said to support the government's strategic release framework provided for in its gas plan. I move now to the Mining and Petroleum Legislation Amendment Harmonisation Bill 2015. No doubt the government says this is its first step towards implementing recommendation 6 of the Chief Scientist's report, which would be a single act for all onshore subsurface resources excluding water. The many changes contained in this bill are designed to bring the Mining Act and the Petroleum Onshore Act into a greater consistency with each other, to modernise, update the provisions dealing with mining and resources, and to extend those to the petroleum sector, to streamline existing arrangements and to provide greater clarity around current industry practices. The bill sets out consistent requirements for the administration of exploration, assessment and production titles across all types of resources, and provides for codes of practice to be set by regulation and for compliance with them to be conditions of each title. These are good steps to be taken. The bill will also make consistent the compliance and enforcement functions under each of the Mining and Petroleum Onshore Acts, including around penalty infringement notices, increased direction powers for inspectors, a new prohibition notice for illegal exploration and mining activities, and the innovation of enforceable undertakings, which we think is actually a very good step. The bill brings the power of departmental inspectors under the Mining Act into the petroleum legislation, where the current powers of inspectors are, well, on my view, weaker, but on another view, simply more limited. Inspectors working under either Act will now have consistent powers and will be able to share information and take whatever compliance action is necessary. The bill also makes provision for the community benefits framework recommended by the Chief Scientist in the third dot point of recommendation 3, which will be established by regulation to permit infrastructure and repairs to be funded by industry levies. And I understand that consultation around the content of that regulation is currently underway, and I'm looking forward to seeing some more detail around that. One potential area of concern in the limited feedback that the opposition has received to date is that the level of penalties for breaching mining and petroleum legislation may not be consistent with the recently increased penalties enacted by Parliament in 2014 for the Contaminated Land Management Act and the Protection of the Environment Operations Act. In terms of the offences provided for in the Harmonisation Bill, I don't think this is a correct analysis. For example, if we look at page 63, Division 6, proposed section 104 capital O, and also later provisions such as the whole of Part 13, capital A, offences, enforcement and undertakings about contraventions, and an earlier provision, for example, found on page 22, Part 17, capital A, offences, enforcement and undertakings about contraventions. As I understand it, these do seem to be consistent with that updated legislation. I do understand that the infringement notices for infringements under the petroleum legislation do have significantly lower penalties than for other environmental offences. But I also note that the Protection of the Environment Operations Amendment Enforcement of Gas and Other Petroleum Legislation Bill 2015, as part of making the EPA the lead regulator and giving it greater enforcement functions directly conferred by legislation, EPA officials will be able to not only use, in relation to the petroleum sector, those infringement notices specifically related to the petroleum legislation, we will be able to use the infringement notices under other environmental laws where appropriate, so they won't be bound simply to use the petroleum legislation mechanisms. Whether that proves to be the case legally, whether or not as a matter of practice that's what the officials of the Environmental Protection Agency authority actually do, only time will tell. We will give the government the benefit of the doubt and hope that things work out here as intended, but we serve notice that should it not be the case, we will return to this issue. I turn now to the Mining and Petroleum Legislation Land Access Arbitration Bill 2015, which is no doubt designed to implement Recommendation 3, first dot point made by the Chief Scientist, and the report of Brett Walker, Senior Counsel in 2014, to improve the balance of power between landowners and title holders in industry. The legislation clarifies the rights of landholders, provides for a dispute resolution framework, including further regulation of arbitration panel members and processes, and updates provisions regarding the boundaries of titles. The bill will make clear that landholders have a right to compensation for production activities that take place on their land, and as I understand the legislation, compensation will be mandatory as part of any land access arrangements. Separate land access codes may be developed for each of petroleum exploration and production separately. Mr Walker, Senior Counsel, made 31 recommendations about dispute resolution, and as I understand it, the bill implements in law those aspects of his recommendations that require legislative imprimatur. The bill places good faith negotiation obligations on all parties, a framework for the payment of the costs of disputes, new provisions around the appointment of arbitrators. There is an explicit legal right to legal representation for mediation and arbitration. The reasonable costs of landowners to disputes will be paid for by industry but capped by regulation. No doubt there'll be some forensic consultation by industry and other stakeholders around what those reasonable cost levels should be. The reasonable cost of landholders for land and environment court proceedings will also be met by industry in this bill. Similarly capped, there are provisions around training, assessment, the appointment and tenure of arbitrators, including a public register of the details of each member of the arbitration panel, and all arbitrated arrangements will be published, no doubt intended to give and promote greater transparency and therefore public confidence in this process. These matters are consistent with Labor policy pronouncements made in this area by the Leader of the Opposition, Mr Luke Foley MP, when he was the Environment Shadow Minister. The Work Health and Safety Mines and Petroleum Legislation Amendment Harmonisation Bill 2015 extends to the resources sector, the whole of the resources sector, now including the petroleum industry, the provisions of the Work Health and Safety Mines Act 2013. At present, the provisions of the Work Health and Safety Act 2011 apply to the petroleum sector, and there are, of course, as the Minister himself noted, the 1992 Schedule of Onshore Petroleum Exploration and Production Safety Requirements specifically governs the sector, although the provisions now are somewhat dated and limited. The framework of broader duties and regulatory oversight for resources provided for in the Work Health and Safety in Mines Act will be extended to the petroleum sector, and the legislation will be renamed the Work Health and Safety Mines and Petroleum Act. The intention is to raise the standard of safety for onshore petroleum operations and make them consistent with those in place for mining, and makes particular provision for the risks attendant in the petroleum industry as well. For example, at present the safety duties rest on title holders, but consistent with the rest of work safety law and practice, these obligations and duties will now be extended, as is common with the rest of OH&S law, to site operators, to contractors, to occupiers and controllers of work premises, and employees as well. So it certainly fills out significantly and extends the occupational health and safety duties more generally across the industry, and we welcome these developments. Finally, the Protection of the Environment Operations Amendment Enforcement of Gas and Other Petroleum Legislation Bill 2015 is said to implement in part Recommendation 7 made by the Chief Scientist, that the allocation of rights to exploit subsurface resources should be separate from the regulation of activities under those exploitation rights with a single independent regulator. The government has stated that the Environmental Protection Authority will become the lead regulator in the area. From 1 July 2015, the EPA became responsible for compliance and enforcement of all conditions of approval for gas activities in New South Wales, excluding work health and safety. At present, it operates under delegations made by other agencies, made under other laws. This bill directly gives those functions to the Environmental Protection Authority. The EPA will be able to exercise the powers provided for in the Protection of the Environment Operations Act to matters arising in the petroleum sector. The opposition, as I indicated, does not oppose these measures. We welcome them. They are a significant improvement on the existing law. To the extent that they are a step, albeit a small step, towards implementation of the report and recommendations of the Chief Scientist in her September 2014 report, we do welcome that. But as I've indicated on that front, this package falls well short of what might have been expected in that space, considering the great deal of public attention and importance that has rested on that matter. More fundamentally, looking at the 5 bills together, I think they run to something like 164 pages, and their significance is probably greater than the number of pages. This is probably the most significant reform package that this government will undertake in the resources sector in this term of office, probably. And we think that it should be done more comprehensively. I do note that obviously the government has consulted relevant stakeholders, as has the opposition, including the CFMEU Mining Division. But I also note, for example, that the Minerals Council have a great deal of significant concerns about aspects of the legislation, representing concerns expressed by their members, no doubt. One area, for example, and I think this is a matter specifically adverted to by the Minister in his second reading speech, and the Honourable the Parliamentary Secretary in the speech incorporated in Hansard here, is that there is no increased regulatory burden for industry. I don't think industry would necessarily agree with that, given some of the feedback received by the opposition. That's a matter for the government as to whether or not it wants to address any of those concerns that have been raised with it. But they will not be the subject of amendments proposed by the opposition here. Our amendments will be in relation to the recommendations of the Chief Scientist and Engineer around coal seam and other unconventional gas. The opposition will also be proposing an amendment around the matter I mentioned in my earlier contribution around the competitive selection process, removing the obligation on the Minister to notify relevant government agencies and to resolve any objections. There is also some concern that in the enforcement bill, the power of the EPA to enforce matters rests on the definition of a petroleum authority, which is provided for on page 3, and it sets out a number of things that are a petroleum authority, but it does not include matters or approvals under Part 5 of the Environmental Planning and Assessment Act 1979. Again, we have an amendment to address that aspect. And finally, there are some concerns around third-party enforcement rights in environmental matters more generally, which this government has shown itself to be antithetical to. We will have an amendment that does address some of those concerns, albeit in a way that focuses on the resources sector. With those closing comments, I indicate that the opposition cautiously welcomes the content of these bills. They are an improvement on the state of the legislation in its current form. It is appropriate for the whole of the resources sector to be regulated in a manner that is consistent and more desirably under the same framework. While at the end of the process of this bill, or set of bills, there will still be separate legislation. The government has indicated that this is the first step towards a single legislative instrument to regulate extractive industries, consistent with the recommendations of the Chief Scientist. A lot more work, of course, will need to be done to achieve that ultimate objective. Thank you, Mr. Deputy President.
Hear, hear.